is an active military one and thus dangerous to civilians. This is admitted by the other side. For example, the commander of the military unit of the NKR Defence Army, Mr. Hamlet Savoyan, declared in his evidence provided in Annex 7 of Armenia's submissions of July 2012 that while there were roads by which people can get to the village, I do not think, he said, that a civilian or military servant of Nagorno-Karabakh Republic can reach there because that's dangerous. A civilian or military serviceman cannot go because there are minefields. Also they, Azerbaijani military, will shoot. We can't provide the security. He continued, they, Azerbaijani forces, cannot guarantee the security of the civilians since the surrounding areas of the village are mined. Of course, Azerbaijan does not accept the implication that the threats of shooting come from its side. Leaving that aside, officials of the NKR clearly accept that the area is dangerous and inaccessible to civilians and military forces alike, due both to the dangers of military confrontation and to the mining of the area. The court has been provided with information showing how heavily the area of Gulistan is mined, and the view of the director of Azerbaijan's National Agency for Mine Action that the village of Gulistan has been defined as an area with extensive mine and unexploded ordnance with no safe access. Further, there are regular incidents of violent outbreaks of firing across the line of contact, including in the Gulistan area. It is an area where fighting erupts from time to time. Jurisdiction under Article 1 is primarily territorial. One of the exceptions is where a contracting party exercises effective overall control of an area of another state's territory, whether directly or indirectly through a subordinate local administration. The normal territorial jurisdiction of a state, therefore, may be displaced where it is unable, as a matter of fact, to exercise control over its territory. It is therefore Armenia which bears responsibility under the Convention for the Security of Convention rights in the areas of Azerbaijan it directly or indirectly controls. The unusual feature in this case, as both Azerbaijan and Armenia agree, is that the village of Gulistan is located right on the line of contact. Both Azerbaijani and Armenian maps agree on this. There is some evidence from Armenian sources that the village itself was captured by Armenian forces during April 1993. Azerbaijani sources state that the Azerbaijani army does not have free access to the village and can only monitor it from outside. And it is covered by Armenian snipers who have a clear view of the village across the river. It can therefore in no way be concluded that Azerbaijan is in effective control of the village. It cannot be responsible under Article 1 in the primary sense of the provision. This is not a black hole or legal vacuum. It is a very specific and very limited grey line along a ceasefire or militarily volatile line. The court has developed the notion of supplementary or subordinate responsibility with regard to a dispossessed sovereign, and I quote, to take all diplomatic, economic, judicial or other measures that are in its power to take and in accordance with international law. Such obligations, as the court made clear in Azemi against Serbia, is fact-dependent. I make the following points. First, the issue is fact and context-dependent. Second, the necessary measures focus on opposition to the continuing occupation of Azerbaijani territories. Third, as to the applicant and those in the same position, Azerbaijan has in place relevant mechanisms. The court underlined in Al-Ashku that a fair balance has to be struck between the general interest and the interests of the individual. The obligations must not be interpreted in a way to impose an impossible or disproportionate burden. The particular context in this case concerns the situation around the village of Gulistan, which I have explained is right on the ceasefire line and thus highly dangerous. Azerbaijan maintains it would be a gross dereliction of duty and a likely violation of Article 2 were it to permit civilians to enter the village. The necessary measures have been analysed by the court as falling into two parts. First, refraining from supporting the regime established by separatist forces, and secondly, seeking to re-establish control. The clear, consistent and continuing opposition of Azerbaijan to the unlawful occupation by Armenia of Nagorno-Karabakh and the surrounding territories, and to the separatist regime established as a result of Armenian arms and sustained by substantial aid from Armenia, is a matter of public record. Armenia seeks to re-establish its control over its occupied territories by all diplomatic means possible. This parallels the requirements laid down by the court in Ilashku and in Ivantok. In our submissions of October 2013, we have summarised the efforts made in this regard concerning the continuing Minsk process. Azerbaijan is also committed to the Madrid principles, one of which is the right of all internally displaced persons and refugees to return to their former places of residence. Contrast this with Armenia's policy of planting settlers in the occupied territories. Thirdly, with regard to the applicant, Azerbaijan has drawn attention to its order of November 1991, which is still in force. This provides a legal framework for the private exchange of properties that were taking place, whereby individual refugees swap their properties. By this way, Azerbaijan has sought to deal with a wholly exceptional and emergency situation. Beyond this phenomenon, the normal rules of ownership operate. This has been described to the court, and the court's summation may be found in Sargsyan, the admissibility decision at paras 37 and following. As far as the applicant is concerned, it is not known whether he obtained the house of an Azerbaijani refugee in the Armenian-occupied areas. His own house was not given to a refugee. So far as is known, he is engaged in no such exchange transaction. To the extent that the applicant maintains that his claimed home in Gulistan was expropriated during the conflict in the early 1990s, he is out of time. Such an allegation is in any event denied. No claim for compensation has indeed been received. It is not possible in the circumstances to resolve the alleged claims of the applicant by specific judicial measures to safeguard his claimed interests, since these have not been under legal attack. Only the practical circumstances prevent access to his property. Thank you, Mr. President. I pass over to Dr. Lansky.
Thank you, Professor Shaw. Dr. Lansky, you have the floor.
Mr. President, esteemed members of the court, all what Mr. Professor Shaw explained has, of course, direct impact on the right to effective remedies according to Article 13 of the Convention. In his current application from 2006, the applicant admits that he has not attempted to exhaust local remedies. Indeed, it is possible for ethnic Armenians to claim effectively their property rights different than what the applicants previously declared. We deny that there are no effective remedies available for the applicant. Azerbaijani law indeed effectively protects the ownership and the possession of property. We do have constitutional regulation and we do have civil code regulation, which sufficiently provides the possibility for indemnization. Of course, one could distinguish between legal restitution, remedies for and procedures here exist, they are not exhausted, and the restitution in kind, which in the specific situation in Gulistan is not possible because of the complete lack of control of Azerbaijan. This does not change the situation that the legal framework for the legal restitution, pecuniary restitution, is existing. There are more than 240 civil claims which have been recorded by the Ministry of Justice between 1991 and 2006 do indeed show, and this is a difference to the situation in Armenia, do indeed show that those are also claims of ethnic Armenians. Close to 100 of those are related to housing disputes. And of course, we have to say the IDP, those are not cases of IDPs, but they are cases who fit into the situation, and they do give remedy also for ethnic Armenians in parallel situations. This is why we can conclude that the applicant did not use these existing effective remedies, and you may declare, in our opinion, the application inadmissible also in this stage of the procedure. Let's switch to Article 1 of the Protocol number 1. There is no other remedy, no other help than to go into the details of the depositions which you find in our case, and there are indeed a big number of inconsistencies and contradictions contained in the applicant's submissions, which seriously undermine the credibility of the applicant's evidence. We have to, let me go through those contradictions. The main declaration of the applicant alleged that his home has been destroyed during the attack on Gulistan in '92. Now, subsequently, the arguments shifted, and the arguments try to develop the position that the house remain standing. You can see in the film submitted by the Armenian government in 2012 that all the buildings in the village have been destroyed. And you saw and you will see in our map, in this AAA report, that there is indeed a complete destruction of all buildings in Gulistan. And if you see, there is, and we carefully studied this map, there is not a single place in which one could see a house which remains standing. How could the applicant's cousin in that situation state that he is able to identify the applicant's home with the use of binoculars from the ceasefire line of Nagorno-Karabakh? The applicant should explain you today how he could view this house. This is an impossible feat, and it has to be asked why they changed position